Next matter to come before the court this morning is State of Ohio versus Curtis Campbell Jr. Each side will have 15 minutes which to present their case. If you're the appellant, you wish to retain some of that time, let me know when you come up to the podium. I'm keeping track of the clock and we'll keep you apprised of the passage of time. We have read the briefs and we're ready to proceed.
Thank you. Good morning, and may it please the court. I'm Christina Madriguera. I'm Assistant State Public Defender appearing on behalf of Curtis Campbell. We're challenging the sufficiency of the evidence in his conviction for tampering with evidence. I'd like to reserve 3 minutes for rebuttal, but I definitely need that time. Under Ohio law, in a case such as this, a possessory drug offense, where the offense is not likely to be reported or investigated, in order for there to be sufficient evidence of tampering with evidence, the state must show there is an ongoing or likely investigation related to that evidence before the person took steps to avoid detection. The Supreme Court of Ohio has already considered and decided whether the tampering statute should be interpreted to encompass all criminal conduct law enforcement may discover, or whether the statute should only encompass tampering with evidence that is related to an ongoing or likely investigation. The Straley and Skorvanik conflict examined that issue. State v. Skorvanik involved 2 police officers responding to a request to stop a vehicle due to an improper left-hand turn. The police officers were in a parking lot when the reported car passed them. As the officers began to follow Mr. Skorvanik's car, both officers saw, I think it was during the daytime, both officers saw Mr. Skorvanik throw a pill bottle from his car window. When the officers completed the traffic stop, one of the officers returned to the place where the pill bottle was discarded and collected the bottle which contained various drugs. Mr. Skorvanik was convicted of possession of drugs and tampering with evidence. He challenged the sufficiency of the evidence in his tampering conviction, arguing that when he threw his pill bottle from the car, the police were only investigating him for a traffic violation, a crime for which a pill bottle would have no evidentiary value. This court disagreed and held that an investigation may quickly proceed beyond its initial purpose, and the fact that officers initially were following Mr. Skorvanik for a traffic violation does not detract from the evidentiary value of the pill bottle filled with drugs. State v. Straley involved a case where narcotics officers lawfully stopped Ms. Straley's car for traveling left of center. The officers decided not to pursue any charges, but would not let Ms. Straley drive home. While the officers were working on finding Ms. Straley a ride home, she indicated she needed to urinate. She moved about 20 feet away and relieved herself. When she was done, one of the officers investigated the area and found a urine-soaked baggie containing crack cocaine. The second district held that based on the record, there was insufficient evidence to support a conviction for tampering. Resolving the conflict in State v. Straley, the Supreme Court held that in order for there to be sufficient evidence to support a conviction for tampering under the statute, the state must prove that at the time of the alleged tampering, there was an existing or likely investigation related to the evidence that was tampered with. In Straley, the Supreme Court of Ohio found insufficient evidence to support Ms. Straley's conviction because there was nothing in the record to suggest at the time she discarded the baggie that the officers were conducting or likely to conduct an investigation into trafficking or possession. And the baggie of cocaine did not relate either to an investigation of driving while under the influence of alcohol or driving without a license, and had no evidentiary value to a likely investigation of public urination. In State v. Berry, the Supreme Court of Ohio unanimously affirmed Straley and further clarified that for purposes of the offense of tampering with evidence, committing an unmistakable crime by itself does not establish that a person was likely to be investigated for that crime at the time the evidence was concealed. Berry involved a lawful traffic stop of the car Ms. Berry was driving. When the officer approached the car, he smelled marijuana, and through talking with Ms. Berry, the officer suspected she had concealed drugs inside her body. Ms. Berry initially denied that she had concealed drugs, but after the officer told her he could obtain a search warrant to have her searched, Ms. Berry admitted she had concealed heroin in her body. The Supreme Court explained that Ohio does not recognize the unmistakable crime doctrine in connection with the offense of tampering, because that doctrine erroneously imputes to the perpetrator knowledge of a pending or likely investigation into a crime. Merely establishing that the crime committed is an unmistakable crime is insufficient to prove that the accused knew at the time the evidence was altered, destroyed, concealed, or removed that an official investigation into that crime was ongoing or likely to be instituted. Thus, the Supreme Court of Ohio has determined as a matter of law that the tampering statute should not be interpreted to encompass the discarding or concealing of contraband in a possessory drug offense when there is no investigation or likely investigation related to that contraband. However, this rule is not boundless. In State v. Martin, the Supreme Court of Ohio clarified that there is a distinction to be made between a possessory drug offense that is not likely to be investigated or reported and a crime that is likely to be reported and investigated, such as a homicide. State v. Martin was a capital murder case where the accused shot 2 people in a residential neighborhood and left them for dead. In addition to the murder charges, Mr. Martin was charged with tampering with evidence for burning his clothes after the shooting. Upholding the tampering conviction, the court explained that although under Berry, Ohio law will not impute knowledge of a pending or likely investigation based on the commission of the offense, the rule in Berry does not foreclose the state from imputing knowledge of an investigation for an offense that is likely to be reported, such as homicide. In this case, if Mr. Campbell tossed the contraband from the car, which we do not concede, he did so in order to avoid detection in a possessory drug offense, an offense that was unlikely to be reported or investigated when the alleged tampering took place. When the contraband was tossed from the car, there's no evidence that Mr. Campbell or Trooper Grimm knew any investigation other than Mr. Dean's marked violation was in progress or likely to be instituted. The list of circumstances that the state puts forth to support that Mr. Campbell knew a drug investigation was likely speak to possession, and they are not sufficient to support a conviction for tampering with evidence.
Let me ask you a question.
Yeah.
Does it matter that in this case there was that concerned citizen that called about reckless driving? I mean, I realize that he was pulled over for a marked lane violation, but there was some concern that there was more than just, gee, you drove over the fog line. There was something going on here more than just that. Does that make any difference at all in this case?
I think it would make more of a difference if Mr. Campbell had been driving. He was the passenger in the car, and it was dark. Mr. Deans was the one that was driving, and it was Mr. Deans' car. So at the time, I think it would make a difference if Mr. Campbell had been driving, but he was not. He was a passenger in the car.
I'm assuming there was no testimony regarding Mr. Campbell's knowledge that Mr. Dean did not have an operator's license.
I can't recall if there was testimony regarding that, regarding whether he knew that Mr. Deans didn't have a license. I think Mr. Dean's license was suspended, is that right? He had privileges, but he didn't have the papers with him. In the Berry case, Ms. Berry's car smelled like marijuana. Based on conversations with her, the officer suspected she had concealed drugs. She denied it. Then she admitted it. That she had concealed the drugs prior to her encounter with the police. In the Straley case, Ms. Straley case was, in the officer's opinion, not fit to drive her car home. The police found her discarded drugs during her encounter with the police. Based on the record in both of these cases, the Supreme Court of Ohio ruled that constructive knowledge of a likely investigation must not be imputed to Ms. Straley or Ms. Berry. We submit that the law requires the same result in this case. There's no evidence in this record to establish that Mr. Campbell was under investigation for possession when the contraband was tossed from the window of the car. And because possession of drugs is an offense that is unlikely to be reported or investigated, any steps he may have taken to avoid detection cannot impute him with the knowledge of a likely or pending investigation. We respectfully urge this court to vacate Mr. Campbell's third-degree felony conviction and sentence for tampering with evidence under Revised Code 2921-12A1. Thank you. I'll reserve the rest of my time.
Good morning, may it please the court. Vince Vellucci again for the State of Ohio, the Medina County Prosecutor's Office, the appellee in this matter. This is a sufficiency argument that's based mainly on, solely I should say, on one argument that Campbell, there's no proof that Campbell knew that an investigation was about to be or likely to be instituted when he threw a bag of cocaine out the window of the vehicle he was in. And Campbell may not concede it, I think she just said, but certainly doesn't dispute that he did actually throw this bag of, it's not being disputed on appeal that he threw a bag of cocaine out the window. The actual cocaine charge has not been challenged here. So all we're looking at is his knowledge at the time. I think that's important because there's a lot of red herrings that I just heard thrown out on the oral argument in terms of who's driving, did somebody call in to report erratic driving, did somebody know that his license was suspended, does it matter what the officer knew at the time, did he think he was specifically investigating Curtis Campbell? None of those things matter in terms of this argument. What matters is, did he know that an investigation was about to be or likely to be instituted at the time he threw?
I have a question for you on that. Is it, did he know that an investigation, as you just said, or an investigation into, I'll just generically say, a drug offense? Because there's a big difference there. So how the Supreme Court lay it out.
Well, in the Skorvanek case and then Straley, it's mentioned in her brief that Straley overruled Skorvanek. Specifically, I disagree with that. Did not overrule its holding. I think it overruled part of its, one of its major propositions, which is that it doesn't have to do with, that the tampering does not have to do with an ongoing or likely investigation. That's what Straley said is not the law. The ongoing or likely, a likely investigation here was going to be a drug investigation.
How so?
Well, if you look at all the circumstances in which he was found seconds later, and I lay it all out in my brief, you have a cut straw right at his feet with residue on it. You have residue, white residue on his nostril, on his shirt.
But none of that happened at the time that the conceded or non-conceded drugs were thrown out the window.
Well, we're talking about what he knew at the time and what he thought to be a likely investigation at the time. And I'll also point out, this case is more compelling even than Skorvanek, because in Skorvanek, the police officer was just following him when he threw the pill bottle out the window with the drugs inside. He hadn't even lit him up with the lights. He wasn't pulling him over. They were pulling over, the trooper was pulling over Campbell and his driver at the time when he threw this bag of cocaine out the window. So he absolutely knew there was going to be an investigation, certainly a traffic investigation. But as I point out in my brief, there's also going to be a drug investigation. There was a needle found that ended up having fentanyl in it. It was also just inches away from Campbell in the car. Again, and I think Straley did not overrule Skorvanek on a couple of other points. Like I said, it was one point was overruled in that case. Another important point that was not overruled is this court stating in that case in Skorvanek that an investigation can quickly proceed beyond its initial purpose. So I think what that's saying is it does not necessarily have to be a drug investigation, because a traffic stop can quickly proceed into something else. If you see, for example, a guy with white residue on his nostrils and all over his shirt and all over his pants and all over his car, and who appears to be acting erratically also, I don't think I mentioned that. When he starts talking with Mr. Campbell, he's showing classic signs of being under the influence of drugs, specifically cocaine. He's talking so fast that the trooper can't even understand him. He's got drug paraphernalia all over his car. He's got drugs all over his car. This case could not be more different, I would say, than both Straley and Berry, those Supreme Court cases. Straley is kind of a unique situation. This young lady had been pulled over and was being investigated for an OVI, which the officers ultimately decided not to charge her, stopped their investigation. There was no investigation now going on. They were apparently just trying to arrange for somebody to come pick her up, I believe. And that's when she does this whole thing of going over to this building and urinating. And ultimately an officer ends up back over in that area at some point and sees the cocaine that she tossed down while she was over there. Well, there was no investigation. There was no likely investigation going on at that time. The investigation was over. In this case, in Campbell, the investigation was just beginning. It was absolutely progress. He's in the process of being pulled over. So I don't think there could be a bigger difference than that. And then in Berry, you have this woman concealing heroin inside her body, as I'll phrase it that way, inside her body hours and hours earlier in the day, before they'd even gotten on the road, when she's only in the presence of her co-conspirators. There's no, in her mind, likelihood of an investigation at that point. That's where the court says you can't imply constructive knowledge of any time that you're committing a crime that there's going to be an investigation. Unless, of course, in the Martin case, it's a murder. The Supreme Court did say that. And I'm not trying to argue this case is like Martin. It's not. So in Berry, she's done the alleged tampering act hours earlier, before there's any investigation, before she knew she was being pulled over. So there, we're way before an investigation. In Straley, we're after the investigation. Here, in Campbell, we are just right during the investigation, and that's when he tosses this bag of cocaine out the window. Frankly, I would say if this isn't tampering, I'm really not sure what is anymore, if this isn't tampering. So, again, lights flashing. This is even more compelling than I would say Scorvana, when they were just following the driver for some suspicious behavior. I think they were about to pull him over, but had not yet when he discarded the drugs. Again, this whole notion that the trooper did not even know the vehicle was occupied by anyone else at the time. Again, it's not about, even if you accept that as true, which I don't know that that's true, but if that is true, it doesn't matter what the trooper knew at the time he hit the lights and started pulling over the vehicle. It only matters what Campbell knew. And anything else is kind of a red herring. What he did know, given all the circumstances, I think you can imply this, is that he had just done cocaine, that he might have residue on or near him, that he had drug paraphernalia in the car, that he either couldn't find or he didn't have time to discard, because it was such a short time. I think a rational fact finder could have found that Campbell knew an investigation was about to or likely to take place, and specifically a drug investigation as well, not just any investigation. Although I don't believe that that's necessarily the standard, but I believe that if this court were to find that is the standard, I think there was enough evidence that in his mind he would have known a drug investigation was likely to ensue. In terms of manifest weight, the jury had the right to make its own decision on credibility, and Campbell did not present any of his own evidence, so there's really nothing to weigh. I would say the evidence actually weighed heavily in favor of the conviction. And just to answer Judge Hensel's question, I don't believe there was testimony as to whether driver's license was suspended or what Campbell knew in terms of that. Are there any other questions? I would just ask this court affirm the trial court. Thank you.
Thank you. You have 5 minutes.
Oh, thank you. I'll just be very brief. Understanding that the standard is that the state has to show that what the defendant knew at the time of the alleged tampering. I just wanted to say, by the time Trooper Grimm decided to investigate the items, he thought he saw coming from the passenger window, an hour had passed. Mr. Campbell, who had been handcuffed and in the back of Trooper Bissonnette's cruiser, the other trooper, he had been released from handcuffs and returned to Mr. Deems's car. Mr. Deems's car had been searched. The pen, the cutoff pen and the syringe had been collected from the car, and Trooper Grimm had determined that Mr. Deems was not driving under the influence. Under the state's view, the tampering statute is violated when steps are taken at any time to avoid detection. The state's job is only to discover the contraband, and it makes no difference what the offense is and when this person took steps to avoid detection. That seems to be the state's view, but it's not the law of Ohio. The unmistakable crime doctrine has been rejected in Ohio. The question then becomes, under what circumstances is knowledge of a pending or likely investigation imputed to a criminal defendant? The answer is when there is evidence in the record or in cases involving a violent felony that is likely to be reported. Because neither of those criteria are present in Mr. Campbell's case, there's insufficient evidence to send his case to the jury, and we respectfully urge this court to vacate his felony 3 conviction and sentence. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be posted to our website and on both sides, posted to the Supreme Court's website as well.
Thank you.